Yeah, it was good, YouTube. Sorry about part one. You know what I mean? I was trying to get one of my guests to come through, give a little bit of, recap on the situation. Sorry about. Oh wow. Yeah, I was setting myself up. But anyway, so right now we're gonna watch the Young Gunner case. I mean Young Gunner, pardon me. The Thugger case that happened. I think it happened yesterday. And we're gonna see. Hey, shout out to the viewer. We about to watch the Thugger case, right? Cause I got a feeling that whatever Gunner did got something to do with going on with Thug case. Cause when he first walked in the courtroom, he was all smiles and all that. So I'm thinking he about to go home. He about to da 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 go. But as I see the lawyer going back and forth with the district attorney, I'm like, I don't know. Maybe he probably could have said something that got Gunner in more trouble. But let me um let me turn the camera around a little bit. Hold on. All right. So let me turn this camera a little bit. Yeah, I could probably just listen.
Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page 10, in order to say, of course. IT is about to create a new secure Zoom link that's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry, continue. That's okay. On page 3, page 34, Your Honor, of Court's Exhibit 2.
This is the court. This is the court video. This is not
Mr.
YouTube
Bailey,
doing
the
it.
district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entry in Mr. Williams' home. Then there are two parts here, and that's the long and short of it. Did they, meaning police, have the right to
There we go.
effect the arrest warrant, and what did they see once they got inside that would rise to probable cause? Then, skipping, Your Honor, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that are challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within.
All right. We're gonna stop this right here, cause in my opinion, I feel like this lawyer is good, right? He's good, but if they ran up in the crib, right, and they didn't have a warrant, don't think it would have went this far. But like he's trying to say that it must have been some crooked situation going on in terms of why they even ran up in this crib. Cause even to me, I don't know. Not saying who knows what Thugger was doing, but nobody had no accusations of him ever doing something extreme. You know what I mean? Like not at that time. This happened what last year, something. But I felt like this was just they was trying to get all the hot rappers out the game for a minute or some shit. That's why I'm just like, okay. But But he sound like he doing good. He sound like he might get thug off. Let's continue. Shit, I'm curious my damn self.
The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional right to violate. He's a victim. The court should say respectfully, no way. This was litigated. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority from the police to go in to effect the arrest warrant. And then we get to the second point. And it is in the same Wall case, Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor on page 36, line 25, concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom, and Detective Gator further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appeal. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A plus game and try to win before this court. That's not the way, I don't get to do that, ever.
But it wasn't appealed. I mean, there was, Judge Newkirk's ruling could have been appealed by the state, or could have been appealed by within 30 days of the entry of the order.
Why would I appeal it?
Well, no, you wouldn't appeal it. But
And the state doesn't appeal. What does that mean? It becomes final. The court cannot amend that order. You'd be amending the finding between the same parties on the same exact issue. They don't get the seconds. In the case law, it says second bite of the apple. Then you're on page 38.
All right. So as you can see, cops be doing some crooked stuff. I know this all my life. When you black, you know this all the time. You know what I mean? But cops are doing some crooked stuff. And Thug is an artist. He got bread, more bread than most people. Cops upset. You know, he might have the city, the key to the city, just meaning like you get mad respect. Feel me? So they just booked him, bro. Cause they do some type of shit where they'll be like, "Oh, we got a warrant for your arrest," or they'll say something. Nah, not even let me say it like that. They'll be like, "Oh," they're knocking your door like, "Oh, your car is parked in the wrong spot." Da 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 da. So now you walking out the crib like, the fuck? I know I parked, but as soon as you walk out, oh, you under arrest. You got a warrant. That's bullshit. Like, the cops be getting away with bullshit, like with some dumb shit. But hopefully my boy Thug will get out and we found out what's going on with Gunna getting out too. Even though I'm not saying he's snitching, it's just a question that I'm asking y'all to comment on. So please comment, let me know how y'all feel. Like, subscribe, share this, hit my Twitter up. I love answering questions, so holler back. But let me get back into this court case right now.
Line 14, this is the district attorney again. So it's just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. once inside, law enforcement saw illegal contraband drugs, that is probable cause to get a search warrant all day long in any jurisdiction in the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39 of the same Court's Exhibit 2, line 1, I get to speak. The court gave me an opportunity to speak. I said, thank you, Your Honor. Your Honor, we are traveling under, I'm assuming the court has it. If not, we'll get you a copy. There was a supplement to motion to suppress, and this is what I'm stressing, sir, Your Honorable Judge Glanville, any and all evidence located.
Even though it's a risk and I don't know what's on the other side, I'm going to make a bet on myself. I guess I'm kind of looking at this as a sort of rebirth opportunity. I just quit my job and flew to Scotland with no money or plans or friends.
This is day one of me exercising every day.
I really going and done it now.
It's about a farm.
Turn in my 2-week notice. I just took the leap.
Yeah, maybe I can have my husband going. I feel like we're on the verge.
Oh, I'm so sorry about that, y'all.
Lawful, and his arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence was not put in evidence while the witness testified or at any other time. The participants in the suppression hearing refer obscurely to the warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put into evidence in the face of a demand. And I continued, I didn't write, I spoke, page 41, line 1, Mr. Williams demanded in paragraph 7 of the supplemental motion and challenged that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is Gaither, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page 42, line 12, I argued to the Honorable Judge Newkirk. So my issue, I said, right, period. So my issue before this honorable court is the first entry, obviously without the arrest warrant at this hearing, is unlawful. Then the second can't be saved by the second entry either, because that would be without lawful blessing. Same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken, should have been suppressed and returned to Mr. Williams. And the state's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk could suppress marijuana is frivolous. On page 43, starting line 4, I continued. But then when the court goes through and looks at the search warrant itself, The only way we would have probable cause in a search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about. And I challenge that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home because I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of a poisonous tree. So I have 3 issues. 1, there is no at all arrest warrant presented to this court. So under Biads, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, everything thereafter falls as fruit of the poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant the motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48, in line 10 in the middle. The only 2 questions, Your Honor, are, did they have reason to believe Mr. Williams would be there? And so they could go into the house and get him. That's it. And then secondly, once they're in the house, did they see something that would give them probable cause to obtain a search warrant? Those are the 2 issues, not whether the arrest warrant out of DeKalb County was valid and whether the case was eventually dismissed or anything like that. The court then, on page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion, which the court file does not have. What does it, what?
There it goes, speaking again.
Back in 2012, we launched our whiskey venture with the debut of our flagship small batch bourbon. In celebration of the anniversary, we've created a
As y'all can see, Thugger didn't get off today. You know what I mean? But I know it's something going on. There's something going on with what Gunna did. You know what I mean? But I'm going to leave y'all with that. And I'm going to get back on tomorrow, see what happens now. All right, love you guys. Subscribe.